$3.8 billion sounds like a verdict. A judge announces the number, one spouse pays, and the other walks away with the largest divorce award anyone has ever seen. But that is not what the public record shows in the divorce of Jocelyne and Alec Wildenstein. The famous figure is a reported package assembled from two very different promises, not a disclosed judgment, and not a single transfer of cash. To understand how a private agreement became a $3.8 billion legend, we have to separate the fortune people could see from the money the courts could actually document. Jocelyne married into one of the most private names in the international art trade. The Wildenstein family had spent generations buying, selling, cataloging, and advising on works whose value could rise far beyond the walls where they were stored. That made the family wealthy, but it also made the wealth unusually difficult for outsiders to measure. A painting can have an estimated value without being sold. A company can control an asset without a family member holding it personally. A trust can provide a lifestyle while making personal ownership look surprisingly small on paper. That distinction became central when the marriage collapsed in New York in the late 1990s. The public remembered the scandal and the tabloid photographs. The legal fight, however, turned on a quieter question. What resources did Alec actually have, and which of them could a court consider when deciding support? The first hard number did not come from the final settlement. It came from a temporary support order while the case was still unfolding. In June of 1998, a New York appellate court reviewed an order awarding Jocelyne $140,000 per month in temporary maintenance. The order also included more than $133,000 in interim legal fees. Those amounts were extraordinary, but the reasoning was even more important. Alec had argued that much of the money around him came through his father, family companies, or other structures rather than through ordinary personal income. The court did not simply accept the smaller number on the page. It said the trial judge could infer additional income from gifts and money channeled through companies said to be owned by his father. It also pointed to what it calls an extraordinarily lavish marital lifestyle. That's the mechanism at the heart of this case. In a support dispute, a wealthy spouse may not be able to end the inquiry by saying, technically these assets are not mine. A court can compare declared income with the life the couple actually lived. If the two pictures do not match, the court can draw an adverse inference and demand more disclosure. An appellate decision also mentioned a Swiss postnuptial agreement. Crucially, it said that the agreement was silent about spousal support. Because it did not resolve that issue, it did not block financial disclosure into Alec's ability to pay maintenance. This is where support law and property ownership can be confused. The court was not declaring that every family, company, trust, or painting belonged equally to both spouses. It was asking what financial resources were realistically available for maintenance while the divorce continued. Access to wealth can matter even when the ownership chain is complicated. That narrower question gave the court room to compare Alec's claimed income with the couple's actual standard of living. This does not mean the court seized a hidden art vault or ruled that every family trust belonged to the marriage. The published decision did something narrower. It upheld temporary maintenance, permitted disclosure relevant to support, and rejected the idea that reported personal income had to end the analysis. That is a powerful ruling, but it's not a $3.8 billion judgment. The marriage itself was dissolved, yet contemporary reporting said the settlement mechanics were still being negotiated in late 1999. What emerged afterward was not a public decision laying out a complete asset schedule. It was a figure repeated by news organizations. The most common version says Jocelyne received a reported $2.5 billion, followed by $100 million each year for 13 years. And 13 annual payments to the initial figure and the nominal total becomes $3.8 billion. That arithmetic explains the headline. It also reveals why the headline can mislead. $2.5 billion plus a fortune stream of payments is not the same thing as $3.8 billion in cash on settlement day. Scheduled payments carry time, collection, and counterparty risk. Their present value is lower than their simple nominal sum. The public reporting also does not give us a complete verified ledger showing when every component was transferred, which assets were included, or whether every scheduled payment arrived. So the honest verdict card needs two lawyers. The widely reported package was $2.5 billion plus $100 million annually for 13 years. The famous $3.8 billion number is the nominal arithmetic total of those reports. The public court record reviewed for this episode verifies temporary maintenance and disclosure rulings, but it does not independently prove a $3.8 billion final judgment. That difference matters because the second half of the story is usually told as an easy morality tale. A woman received billions, spent recklessly, and ended up bankrupt. The real record is more complicated. Alec Wildenstein died in 2008 before a 13-year payment schedule beginning around the settlement period would naturally have finished. Public reporting has offered different explanations for what happened to later payments and family support. Without the underlying agreement and payment records, we cannot turn those accounts into a precise balance sheet. What we can document is that severe financial trouble followed. In March of 2018, creditors filed an involuntary bankruptcy petition against Jocelyne. In May, she filed her own Chapter 11 petition. A later federal bankruptcy decision describes a dispute over an emerald and diamond jewelry suite. 4 post-dated checks had been issued, the first check bounced, and the jewelry had been pledged to a pawnbroker for short-term loans. The court found that a debt of $268,000 would not be discharged. That proceeding does not tell us where billions went. It does prove that by then, the public image of unlimited wealth was colliding with unpaid obligations, pledged jewelry, and bankruptcy litigation. Jocelyne died in Paris at the end of 2024. Obituaries repeated the multi-billion-dollar settlement figure because it had become inseparable from her public identity. Yet the most revealing number in the story may not be $3.8 billion at all. It may be the $140,000 per month that a court could actually see and explain. That temporary order showed how the system worked. Reported income said one thing, the marital lifestyle said another. Family companies, gifts, and a Swiss postnuptial agreement created layers between ownership and access. The court responded by looking beyond the simplest paper answer. The reported final package then magnified that conflict into a global headline. $2.5 billion, $100 million a year, 13 years. Added together, they produced a record-sized legend. But the legend erased the difference between an upfront transfer, a payment stream, a nominal total, and a verified judgment. The settlement report verdict is therefore not that Jocelyne won $3.8 billion and lost it all, it's that a private divorce produced a widely reported package with a nominal value of $3.8 billion, while the public legal record proves only selected parts of the financial fight. Alec was the reported payer. Jocelyne was the reported recipient. The headline total was $3.8 billion over time. The verified public ruling was temporary maintenance of $140,000 per month, interim legal fees, and expanded financial disclosure. One number became legend. The documents tell a more careful story. In fortunes built behind companies, trusts, and private agreements, the largest figure is often the easiest part to repeat and the hardest part to prove.